My lord, may I be permitted to mention this matter for inclusion in the list?
The lordship's leave manner for inclusion in the list of testamentary suit of the year 2014. A testamentary suit of the year 2014, my lord, for inclusion in the list.
May I permit to mention for inclusion of
My lord, dear, this matter has been assigned before your lordship. My lord has heard this. Assigned.
This, I believe, is the Gautam Roy, my lord, in a good investment provider.
Original side, commercial division, item number 1 and 2.
May it please your lordship.
Section 34.
Yes, your lordship had heard me. Then, my lord, I had the cases. My lord, kindly take my note. I'll take 5 minutes only. Your lordship, my lord, wanted me to, my lord, prepare the compilation of cases which are referred to in my note. My lord, I prepared it for your lordship's kind convenience. Now, my lord, my lord, kindly take my note, my lord, once. My lord, I had, my lord, submitted also on the last occasion that, my lord, I will give a case which is not mentioned in the note. But, my lord, your lordship wanted a case on this, that, my lord, for completeness sake, that, my lord, if the decision is not in accordance with the contract, my lord, then, my lord, it falls foul, my lord, of, my lord, the provisions of section 34, and therefore, my lord, it's a ground for setting aside. So if your lordship takes my note, I'll just tell your lordship, my lord, paragraph 4 of my note, just after the table. Lordship has that, my lord? Paragraph 4. The heading is Learned Arbitral Tribunal has rightly dismissed the claim of the respondents. Lordship has that, my lord? My lord, under subclause E, my lord, if your lordship, my lord, kindly makes a note, my lord, it is, my lord, subclause E reads, it is settled law that the arbitral tribunal is a creature of contract. The learned arbitral tribunal cannot pass an award contrary to the terms of the contract, and more particularly the mode of termination agreed therein. Lordship has that, my lord?
Your point was there is no provision in the agreement or contract, whatever that might be, that the very claim, the very ground on which your claim was dismissed,
There's no provision, my lord.
there is no provision in contract. So outstepping the contract
Correct.
or importing something which is alien to the contract.
Lordship is absolutely right. Lordship wanted a case on that. My lord, I have, my lord, in the compilation.
But that is possibly not in your notes of argument,
Correct.
specific point.
No, it is there in the note, but I have not given the case.
Which one?
My lord, that is, my lord, today in the compilation which I have handed up, my lord, the last.
Indian Oil Corporation,
Correct. My lord, 2022.
140 to 165.
463, my lord, paragraphs 43 to 47. But if your lordship, my lord, looks at my index, my lord, I've given the relevant paragraphs there which your lordship wanted marked out. And my lord,
One is wrong interpretation or say,
my lord, I won't trouble your lordship with interpretation. My
this
lord,
is not the issue.
no, my lord, let's put it this way. My lord, the claimant, my lord, who had said the contracts to terminate it, and my lord had claimed damages. My lord, the court, the arbitral tribunal held that the termination was bad.
Rather imported certain terms.
No, for the claimant, my lord, they were the claimants. My lord, the arbitral tribunal held that termination was bad. I'd shown your lordship the clause. My lord, it's not a case of, my lord, a no-fault termination. My lord, for termination to be there, my lord, there has to be a breach. And my lord, there are 3 notices which have to be given: 90 days, 60 days, and then 30 days for the purposes of curing the breach. None of those notices had been given. Therefore, my lord, the arbitral tribunal found on facts that no such notices were given. Therefore, termination was bad. Now, my lord, I had a counterclaim. My counterclaim was based on termination is bad. Therefore, I am entitled to damages. The learned arbitral tribunal, my lord, held, no, my lord, I would also have to give notice for, my lord, the claimant, my lord, to cure.
This is not in the contract.
So, my lord, first thing, my lord, is, my lord, I raised, my lord, 3 grounds. One is, my lord, it's not in accordance with the contract. That itself is a patent illegality. Second, my lord, the, my lord, reason, alleged reason given my lord, is, my lord, actually unintelligible. Why? It follows from what is first, my lord, that it's not in terms of the contract. Therefore, it is unintelligible. Therefore, there is no valid reason. My lord, that itself, my lord, is also a ground. And third, my lord, on the face of the contract, this is not a conclusion which could have been arrived at by any reasonable person properly instructed. My lord, the classical test, my lord, of, my lord, the writ jurisdiction also, my lord, that. So these were the three grounds. Now, my lord, I had cited the other cases which your lordship wanted to be put into a compilation, which I have done. Now, my lord, all the earlier cases, my lord, which I have, my lord, referred to, my lord, they are there. My lord, Somdat Builders, my lord, your lordship will find.
Associate builders are referred to. Sangyong is also referred to.
Now, my lord, this case I had said, my lord, I would give your lordship the last one, Indian Oil Corporation.
Refer to these two cases.
Yes, my lord. No, Indian Oil, my lord, says, I have, my lord, cited all the others. Then your lordship said that the cases were in loose form to put it in a compilation with, my lord, the relevant paragraphs. So I've indicated in the index the para numbers. my
Yes,
lord,
I've
of
seen
all
that.
these cases. So, my lord, only one case, Indian Oil Corporation, which I need to cite. My lord, kindly take page 140 of the compilation.
Yes, I've seen that.
Yes. Now, my lord, kindly come to para 43, my lord.
43 onwards, there is a reference to Sangyong and
Yes.
associate builders.
Yes, my lord.
Both are referred to.
One thing I want to show your lordship, my lord, here. My lord, that, my lord, what is important here, my lord, in para 43, lordships will find, my lord, that, my lord, at, my lord, paragraph 43, my lord, this is the most important paragraph. An arbitral tribunal, being a creature of contract, is bound to act in terms of the contract under which it is constituted. An award can be said to be patently illegal where the arbitral tribunal has failed to act in terms of the contract or has ignored the specific terms of the.
This is your key point.
This is the key point, my lord, which I wanted, my lord, to, my lord, cite. And my respectful submission is kindly insert this case in the note which I have given, my lord, in para 4E,
Para 4E.
my lord, which will be, my lord, I believe, my lord, in, my lord, page, my lord, 7, bottom it starts of the note. Lordship has that, my lord.
Yes.
Now, my lord, kindly add it, my lord, just after para 4E, my lord, it's 2022, 4 SCC 463. Which is, my lord, the last case, my lord, in the compact. My lord, rest of the cases, my lord, I've already cited. So, my lord, now, my lord, if they are to address on their 34 and my lord respond to my. My lord, may I have your lordship's kind leave, my lord? Obliged. My juniors are here, my lord.
And I appear for the claimant in the arbitral reference, my lord. Your lordship, Mr. Mukherjee has placed these authorities. This is, my lord, the well-settled law on the subject on the scope of judicial interference at the Section 34 stage. There are some subsequent judgments of the Supreme Court, also a larger bench, which I'll place before for your lordship's kind consideration. My lord, parties before your lordship cannot possibly make this into an appeal because it is not an appeal. This court is not sitting in appeal over the arbitral law. The scope of interference is within the four corners of Section 34. Mr. Mukherjee has raised three grounds on which he supports his Section 34. I have three separate grounds on which I support my Section 34. There are two Section 34 applications before your lordship. My Section 34 application is based on three grounds. One is failure to consider evidence on record is itself a ground to set aside an award. This was always the law. Now a larger bench of the Supreme Court in a curative petition has held that earlier the law was that evidence not considered is itself a ground to set aside. So if there are some letters on record or there is some oral evidence which the learned tribunal fails to take into consideration, that is a ground for setting aside the award. The law as it was earlier was that if the evidence has been considered, then the court will not interfere at the 34th stage. Now, in a curative petition, the Supreme Court, a larger bench of 3 judges, has held that even if evidence is considered, but the consideration of the evidence is so implausible that no reasonable person could have arrived at such an appreciation of the evidence, then that is a ground for setting aside. My case before your lordship is slightly higher. My case is that the evidence is not being considered, and some parts of it which have been considered are so improbable, or the conclusion drawn from such evidence is so improbable that it will shock the conscience of the court, and your lordship will be pleased to set aside the award on that ground. One is non-consideration of evidence. The second ground, my lord, is that non-consideration of a term of a contract. The learned arbitrator, as Mr. Mukherjee has placed before your lordship, has held that the notices were not given, and therefore the termination procedure provided under the contract has not been complied with by the claimant. Notwithstanding that, the learned arbitrators have failed to consider a separate ground which is available in the contract itself for termination. That clause specifically says that apart from the procedure given above, that is the default, then the notice remedying the default, the 3 notices which Mr. Mukherjee referred to, 90, 60, 30. Apart from that, there is a separate mechanism which the contract itself provides for termination, which the learned arbitrators fail to consider. So these 2 grounds are in the alternative, my lord. My first ground is A, I have complied with the 90, 60, 30-day procedure, which the learned arbitrators have failed to consider evidence on record. Second ground is, my lord, without prejudice to the first and in the alternative, the learned arbitrators have failed to consider the alternate mode of termination which the contract itself provides. That is my second ground. Third ground is this, my lord, that the construction of the terms of the contract is so implausible, and that is where both our grounds are common, my lord. The third ground which Mr. Mukherjee addressed, your lordship, the construction of the terms of the contract is so implausible that no reasonable person could have arrived at that construction. It is an impossibility. It is not plausible, it is an implausible concept. Those are my 3 broad grounds. The fourth ground is this, my lord, and this is somewhere which will meet with Mr. Mukherjee's challenge also, that if the reason for termination, and where I deal with his section 34, is that the terms of the contract which provide for termination are identical for both parties. The 90, 60, 30 is the same for him, it is the same for me. The 30-day, the other clause which provides for termination without this 90, 60, 30 is available for him, available for me. If I were to succeed in my 34, he will automatically succeed. If I were to fail in my 34, the test is the same. His 34 must also fail. Because if your lordship holds that this termination is correct, then his 34 automatically succeeds. But if your lordship were pleased to hold that my termination was not correct, then his 34 must also fail, my lord, because he has to also follow the same termination methodology. He can, if I have terminated in breach of a clause of the contract, then that is a breach on my part. He cannot, then he has to give me notice to rectify that breach or remedy that breach, because that is what the contract provides. He has not done that, and he has come straight to court with a counterclaim. So, my lord, both of us in some way are sailing in the same boat. Now, your lordship has seen the panel of learned arbitrators. Within the 4 corners of section 34, we have to satisfy your lordship, my lord, of our respective cases. But his added advantage is that if I succeed, he automatically succeeds. That is his only added advantage he has. My lord, he has relied on certain judgments. May I come on the next day with my compilation of judgments and satisfy you?
Let me also go through these judgments.
Yes. Beg your pardon?
Let me also go through these judgments.
Please, ma'am. Yes. And one more ground, I was not there at the arbitration stage, my learned friend rightly points out. The arbitrator, in dismissing my claim, have relied upon 12 judgments behind my back, that is, which were not cited by either of the parties.
So you are not able to counter those.
I was not able. So that is a breach of violation of natural justice. I did not have a fair and effective opportunity to meet the case which the arbitrators thought of, which was not propounded by the respondent. So that is a clear ground for setting aside an award. That is covered in the decision which my learned friend has cited, Associated Builders and Sangyong. There are specific paragraphs in both the judgments which say that the arbitrators cannot rely upon material behind the back of the parties, to which the parties have.
That is basic principle.
That is basic principle. Even your lordships don't do that, for that matter, my lord. So, my kindly give me some time.
Hard in part.
Only one thing, my lord. Mr. Mukherjee has argued our section 34. Well, I suppose my learned friend will have to respond to our section 34 and then separately move his section 34.
Yes, yes, I will do both.
So otherwise,
So
that
your
was the-
argument, notes of argument which you will file will have, that must have two parts.
Please, my lord.
One is countering their argument
Please, my lord.
and second is defending your case.
Please, my lord.
because your
So
lordship,
that when you defend your case, they will be able to counter their argument.
I
because lordship was very clear that I will hear Mr. Mukherjee was instructed that you move your section 34, don't go into their area. Territory. So, my lord, let my learned friends, my lord,
You cannot make that because unless you hear them, you cannot counter that.
only one more inquiry, my lord, just to, my lord, be ready for my learned friend's arguments. My lord, when my learned friend refers to the curative petition, my lord, I suppose he's referring to the DMR sale case.
Yes.
Very good.
Did bolo. Very good. February.
Grateful, man.
Heard in part adjourned to 7th February.
Grateful, man. Deeply obliged. But if I can only request Mr. Shah for a copy.
এইটাকে ঠিক করে লিখতে বলবে মানিস লিখছে কেন মানি
আচ্ছা, আচ্ছা।
অ্যাপোস্ট্রফি যাবে নামটা ভুল হচ্ছে তো আগের বারও বললাম let me see what is in the petition petitionটা দাও না
Your lordship is inquiring to our petition, my lord.
no the name is wrong
I'm sorry.
মানিস yes মানিস লিখছে কেন
Order. Money.
yes
Grateful. Deeply.
Lordship, appearing on behalf of the plaintiff.
Lordship, I am appearing on behalf of the defendant. Lordship, DA3 is wrongly appearing in my lord's list. That was my application for extension of time to file the written statement. Lordship, the written statement has since been filed. It has been taken on record by my lord. On the last occasion, my lord had been pleased to dispose GA3. But my lord, it is perhaps still wrongly appearing in the list.
and what is about GA4
GA4, your
GA4,
lordship,
my
this
lord,
is
is
my
the plaintiff's
application.
application.
My application under order 13, your lordship, for summary judgment.
Yes, my lord, on the last occasion, directions were passed for exchange of affidavits. Lordship, candidly, I have overstepped my time to file the affidavit in opposition. My learned advocate on record is carrying the original to court. My lord kindly grants me leave to file it, and lordship directions
This
may
is
be
AO.
passed for.
GA3 of 2000
GA Com 3, my lord.
GACOM 3 of 2024 was disposed of in terms of order dated 22nd November 2024. Full stop. Therefore, comma, it will not appear in the list again and shall be so treated. Full stop. Exchange of affidavit was directed in terms of the previous order dated 22nd November 2024. Full stop. Affidavit in opposition is filed today. Exchange of affidavit in GA4 लिखा था उधर GA4 of GACOM 4 is filed today. Let the same be kept in record.
Lordship, 2 weeks time.
No, last day you were given time
Lordship, they had filed today.
2 weeks. Let the suit appear in the list. Let the applications and the suit appear in the list on 10th February for hearing and filing affidavit in reply.
Served a copy to the other side.
I'm deeply obliged, my lord.
Item number 5.
For the plaintiffs in this matter, my lord. Since inspection and discovery, my lord, in this matter is completed, it is being kept today, my lord, for framing of issues, my lord.
Discoveries inspections are complete.
Yes, my lord.
You are defendant.
I'm for the defendant.
Order sheet টা দাও Suggested issues? Your suggested
My
issue?
suggested issues is not ready yet, my lord. I'm praying for some time. I will bring the suggested issues on the next.
Learned counsel for the defendant. 6 for accommodation to file suggested issues. That this would appear in the list on 7 February for filing framing of issues. Suggested issue filed by the plaintiff be kept in record. Suggested issues.
Item number 6. Commercial division, item number 6.
Lordship, on the last day, Lordship had directed that we file the statement of truth and the list of documents.
Have you filed this?
It has not been filed. My senior, Mr. Shivshankar Banerjee, seeks 1 week of time. So that
On prayer of the learned counsel for the plaintiff, the matter is adjourned to, suit is adjourned to 31st January.
Regular list. Item number 1.
My lord,
I'm the plaintiff, my lord. This was marked as an undefended suit, my lord. It is appearing today as to be mentioned. Let it appear, my lord, any day, my lord.
Judge's brief.
Judge's brief, I'll file.
Witness action.
Witness action, I'll bring on the next date, my lord. If it can be fixed on 15th, my witness will come. I'll
My lord,
file judge's brief of documents.
I'm appearing for the successor of the defendant company, my lord. My lord, this
Successor of this is a company. How can there be a successor?
My lord, I'm explaining how. My lord, on 31st July 2019, the defendant company had transferred its business to India Bull Securities Limited, my lord. And thereafter, approvals were obtained from regulatory authorities, my lord. And thereafter, my lord, in 2020, the name of the transferee company had changed to Dhani Stocks Limited, my lord. And my lord, on 6th December 2024, we have indicated all these facts to the plaintiff directly, my lord. So they have to take steps. Yes. For substitution
My
of
lord,
the.
if my lord kindly takes up the cost title, it says India Bulls Ventures Limited, formerly known as India Bulls Securities Private Limited. If
Look, it's your headache. It's your baby.
Right.
Because if the judgment is passed
my lord,
in your favor and in the name of wrong defendant, that will be useless.
I'll take steps if it
Yes.
is done. I'll
My
take
lord,
steps.
until the substitution takes place, I cannot file an application seeking recalling of the order, my lord.
They can always intervene and do that if they did not choose to appear when the summons was served on them.
No. If it is in the name of the wrong defendant, then what would the views of the suit?
But I'll take steps if it is. If I'll take instructions if it is. I will keep it on the 15th. I'll take steps in the meantime. If
Not 15th. Yeah. 16th?
Right.
Adjourn to 16th January. For taking steps.
Item number 2.
My lord, in this matter, I have been responded 14, my lord, for election for India.
Lordship, my lord. There was a redaction, my lord, for depicting substituted service on the last occasion.
Have you done this?
Yes, my lord. May I find, my lord, the affidavit of service, my lord, depicting, my lord, substituted service, my lord.
You are for?
14, my lord, 14, 1-4. My lord, that is Chief Election Commissioner, my lord.
Chief Election Commissioner. Have you filed WS?
No, my lord, I will not file an WS because I have a fear before lordship that I will file an application where it states that Election Commission India cannot be made a party to the election petition, my lord.
Right.
So there are certain judgments, my lord. I will file an application to that because
So you have to file application then, expunging the name.
Yes, my lord. Yes, my lord. For your lordship consideration.
As far as, my lord, the other respondents are concerned, my lord, they were to file their written statement. That is the defendant number 1 to 5.
7 to 11, 14 and 15.
That's not other than 14, my lord.
Shamanto, I'm just reading out the last order. You're
Yes, yes, yes,
appealing
yes,
for
yes.
a statutory
No,
authority.
no, no.
Constitutional
I
authority.
understand.
You should
I
know.
understand.
Stop.
In terms of the order dated 21st November 2024, it was noted that in the order, in the order, postal articles could not be served upon respondent number 6, 12, and 13 for insufficient address. However, full stop there. However, postal articles were served upon defendant number 1 to 5, 7 to 11, 14 and 15. Full stop. Direction was given to file written statement. Liberty was given to file written statement by the defendant number 1 to 5, 7 to 11, 14 and 15 on or before the returnable date. Full stop. A direction was also given to take steps for substituted service of summons to reach out the respondent numbers 6, 12, and 13. Full stop. Paper publication was also directed as substituted form of service, substituted way of service. Full stop. Next para. Mr. Bhattacharya, the learned counsel appearing for
For the petitioner.
petitioner, files affidavit of service today. Showing publication in 2 Bengali daily. On 20th December 2024. So I have to give at least 1 month's time.
But 1 month's time in so far as, my lord, the respondent number 6, 12 and 13 are concerned.
Yes. Fix 31st January for filing of written statement by defendant number 6, 12, and 13. Full stop. Next part. The learned register shall submit a report. Register original sites shall submit a report on whether defendant number 1 to 5, 7 to 11, 14 and 15 have made appearance or have filed written statement, if any.
But on the last occasion, my lord, the respondent number 1 was represented, my lord. Mr. Ahmed, along with Mr. Torovdar and Mr. Banerjee appeared, my lord.
That's I have to ascertain whether written statement is filed in the department or not.
Filed in the department.
So if the report comes that way, I have to pass necessary order depending on the report.
While submission is kindly recorded, my lord. Person of 14, my lord. Because I will not file a
Next,
written
আরেকটা
statement, my
কথা
lord.
লেখো। As prayed for, leave is granted to Mr. Shamanto, representing
I think 14, my lord. You know, 14. Chief Election Commissioner.
respondent number 14,
to file appropriate application for expunging the name.
I'm grateful, my lord.
My learned friend is possibly also submitting that he will not be filing any WS, my lord.
No, if there be
No, my lord.
expunging, then let that be done.
Law says, my lord, they may not be necessary parties, but proper parties.
Yes.
Grateful.
I'm grateful, my lord. I'm
Having
grateful.
the opportunity of wishing a very happy English New Year.
Same to you. Thank you.
Same from me also.
I'm grateful, my lord.
Item number 3.
My lord, item number 3, my lord, I appear for the plaintiff lordship.
What is
My lord, I
CA1?
had filed an application, my lord, for transfer of the suit to the commercial division. And my lord,
Which one? GA1 or 7?
GS7. GS7.
GA7.
GS7.
My lord, I was supposed to file my written notes of arguments today, lordship. But my lord,
Where
on
is
the
the plaintiff?
request of
আচ্ছা এখানে আছে ছেড়ে দাও
on the request of Mr. Jishnu Chaudhary, my lord, if this matter can be kept any day next week, lordship, he wishes to make some submissions. My lord, he's out of station today.
On prayer of the learned counsel for the plaintiff, the suit and the applications are adjourned to
Any day next week.
আমি থাকবো না 28 না সরি 28 29 27 28 29 দেখো 27th 27 January
27 January.
Item number 4.
Lord, 27. Lord, then that case, Lord, kindly takes it up on first week of February.
the first week of February there are 2 holidays
Yes. 3, 4.
3 and 4 so let it be in the next week
Next week, yes, my lord. Kindly.
Next week.
Yes, ma'am.
Next week.
no second next week
2nd February.
12th February
Very good.
I'm for the defendant in this matter.
Appear for the plaintiff, your lordship will
why do you appear you used to appear online virtually
On the last occasion, your lordship directed the department to transfer this suit in the commercial division. Whether it has been transferred or not.
Your lordship was pleased to direct the department to take necessary steps. Your lordship will kindly take up the order dated
10th of December.
see the order dated 24 September 2020
24th September 20.
বলে দিচ্ছি order did you on with this is Bhattacharya?
the suit is being treated as a disposed of suit Something is pending before the arbitral tribunal.
That's a different part, my lord. Different issue altogether. It's a pre-suit dispute, my lord. And that has also been concluded, my lord. A challenge under section 34 is pending. No. Arbitration was
CS, this suit cannot stand. CS 47 of 2007 is disposed of along with connected application.
my lord is referring to
This order. Is disposed of. The suit is no longer in existence. Go to second page.
Now thereafter, my lord, after 2024, not less than 50 orders have been passed. Not less than 50 orders have been passed. And after this 2020, a
Come with the
special
compilation of order then.
a special referee was appointed. A special referee has submitted a report that has been taken on record. Exceptions have been taken by my learned friend. Various proceedings have taken place, my lord.
But this suit is treated as a disposed of.
That is the recording. Absolutely, my lord. We have also.
How these orders can be passed? That was not placed before this court.
Then a formal, my lord, order is required, my lord, to. Correction of the order.
You check it. I'm just adjourning, simply
uh,
adjourning it.
With a correction of the order dated 21st September and mention this matter after the correction is made. Whether the correction is made. We will check it once, my lord. We'll check this once, my lord.
Otherwise, all the orders which I have passed are infractuous.
We'll check it.
Adjourn to.
We'll give a week's time and we'll do it. Order.
একটা কাজ করো 24শে সেপ্টেম্বর 2020 পরের অর্ডারটা কি আছে দেখো তো আমার এখানে যা দেখে 26 অগস্ট 21 মাঝখানে কোনো অর্ডার থাকার কথা making it not this week. Let me check the order sheets also. No, not all the orders. Need not. Give me this. Give me this. Order was passed on.
September 2020
21 মনে আছে।
21 সেপ্টেম্বরের পরে 24 সেপ্টেম্বর
24th September 2020.
তারপরে 22
Then next order I see 26th August 21. Whether in between order is there or not.
এই তো 22 12 20 অর্ডার প্রেস করেছে 22 ডিসেম্বর 20 22 ডিসেম্বর 20 পর 22 ডিসেম্বরের 20 পর নিচে
22 ডিসেম্বর
উপরে উপরে 22 ডিসেম্বরের পর 10 আর 10
This is one order then. Come with the compilation. Or simply make it, I'm giving you some accommodation. Adjourn to 1 week time, 2 weeks time. 20th January. Because I have to pass an order. When if the department says that it is disposed of case, then I have to, yes. But there must be a link. Possibly order of the division bench has not reached the department. That's why there's a communication gap.
This post of, but thereafter once this poster is uploaded, they take a note of it once this post of, thereafter they have uploaded 50 orders in that.
একটা কাজ করো তো কমার্শিয়াল ডিভিশনের রেজিস্ট্রারকে একবার ডাকো তো
রিপোর্টটা
Mr. Dasgupta appeared in this case. ডিভিশন বেঞ্চের অর্ডার আছে ওই অর্ডারটাকে স্টে করা যে কারণে সাবসিকুয়েন্টলি অর্ডারগুলো হয়েছে ডিভিশন বেঞ্চের অর্ডারটা কমিউনিকেটেড হয়নি ওই অর্ডারটা স্টে আছে ডিভিশন বেঞ্চের অ্যাপিলটা মাস্ট বি ডিসপোজড অফ there must be some final order in the appeal
Going to take everything. Last week. Last week.
এবার লেখো, অর্ডারটা লেখো, ওটা যা লিখেছো কেটে দাও। Peruse the report of the Learned Register Commercial Courts Division dated 13/12/24. Full stop. The report refers to the order of the single bench dated 24/9/2020, by which the suit was disposed of. I was just now inquiring about Mr. Dasgupta. It is stated in the report that the suit cannot be converted into commercial suit since it is an disposed of, within quote, disposed of. It is a disposed of suit. Full stop. The learned counsel for the party submitted final order that the learned counsel for the party submitted that against the order, an appeal was preferred, which was heard by the division bench and finally disposed of in terms of order dated 22nd April 2021. Full stop. The said appeal, APO 116 of 2020 was disposed of by the division bench, setting aside the impugned order dated 24 September 2020, with the specific direction that CS 47 of 2007 be revived. Full stop. While preparing the report, the Learned Register Commercial Courts Division there might be a miscommunication in this regard. Full stop. The Learned Register Commercial Court shall take note of the order passed by the division bench in APO 116 of 2020, dated April 22, 2021. Full stop. The suit, namely CS 47 of 2007, shall not be treated as disposed of. Full stop. Conversion of the suit into a commercial suit. Conversion of the suit to a commercial suit and transfer of the same to the commercial division should be done expeditiously by the department. Copy of this order, along with a copy of the order dated 22/4/2021, passed in APO 116 of 2020, be communicated to the Learned Register original site, Register Information and Technology, Register IT, as well as the Register Commercial Courts Division. Let the suit appear in the list after conversion on 19th February. It is that matter. Name was given before birth.
Item number 5 and 6.
I appear on behalf of the plaintiff, Your Lordship.
Two suits are there. ওই একই order করো. You are for? Have you made discoveries and inspections?
No, Your Lordship, that has not been.
Discoveries, inspections, disclosure of documents, as well as admission and denial are yet to be complete. The suit is adjourned to 27th February. All these exercises shall be done in the meantime.
Grateful, Your Lordship.
The suit will appear in the list on the returnable day under heading for framing of issues.
Grateful.
Enough time is given. Who is plaintiff?
I'm for the plaintiff.
Defendant?
Item 7.
Suggested issues or
may I-
discovered? Suggested issues. Discoveries, inspections, all are done.
And one thing, my lord may recall that, my lord, initially, my lord, a decree was passed in this suit, my lord, the defendant, my lord, preferred an application under order 9, my lord. Thereafter, my lord, we preferred an appeal that was allowed, we preferred an appeal, my lord. Thereafter, it was remanded back by the appeal court, my lord. While, my lord, remanding back, my lord, certain directions were, my lord, timelines were, my lord, set out by the appeal court, my lord, with regard to, my lord, the trial of the suit, my lord. Thereafter, my lord, somehow, my lord, we, my lord, derailed from that, my lord, timeline, my lord, the defendant, my lord, preferred an application before the appeal court, my lord. In that application, my lord, the appeal court has directed, my lord, this honorable court, my lord, to frame its own timeline, my lord, with regard to, my lord, the trial of the suit. But may I, my lord, hand over a copy
Let
of
the issues be framed today.
and the issues, my lord, the suggested issues.
ওটা আসবে চেম্বারে অর্ডার দিয়ে দেবো, ওটা দিয়ে দেবে, চেম্বারে দিয়ে দেবে. This is item number 7. এটা দিয়ে দেবে. Written statement, claim, দুটো suggested issue, এই দুটো দিয়ে দেবে, এই দিয়ে দেবে. Any counter claim?
Yes, there is a counter.
No counter claim.
Item number 8.
Who is in 8? Who is the plaintiff? Rejection of plaint. Liberty was given to you. None appears for the plaintiff. এটা একটু রাখো, ওই আগের অর্ডারটা দাও। এ দেখো, এইটা ভুলটা কোথায় হয়েছে, এই স্যুটটা আমি কমার্শিয়াল কোর্টে কনভার্ট করেছিলাম, তো ওরা কিছু করছিল না।
Item 8.
None appears for the plaintiff. Suggested issues filed by the learned counsel for the defendant be kept in record. Adjourn to. I will not frame issues right now. If they do not appear, I will simply dismiss the suit for default. 17 January. Order change করো. She is there. I was about to dismiss the suit.
I'm deeply obliged for your kindness.
Suggested issues,
I have filed.
and today you are filing that. এটা দিয়ে দিও, তাহলে এটাও দিয়ে দিও। আমি suggested issue, I will frame the issues. But if you want to file order 7 rule 11 application, you are at liberty to file, because that liberty has been given. That will not stop framing of the issues. ওই দুটোই দিয়ে দিও, ইস্যু ফ্রেম করে দাও।
9 and 10.
Item number 9, I am appearing for the plaintiff. My lord, I am led by Mr. Chaudhuri. We have, my lord, concluded our submission and filed our preliminary reports.
Nirmal Kanodia.
Yes. An application for leave to adduce additional evidence. There was one document, list of shareholders, because the dispute revolved around transfer of a company. And the case made out by them in course of their evidence, that application, your lordship has been pleased to dismiss. Now, we have preferred an appeal from that order. The client wanted to test it because a lot rides on that one document. But that I understand will be listed. Returnable.
I am giving you 1 month's time.
My lord,
I've been grateful.
my lord, only
I'm
one
grateful.
thing. My lord, 2011 suit, my learned friend's suit is
My
2012.
lord, I am the one who is
See,
out
when
of
the appeal
pocket.
is pending,
I am out of pocket. Their claim is for damages. I am claiming recovery of money that I have already given them.
3rd December
1
is
crore.
the order, my lord, of dismissal.
in view of pendency of the appeal, argument is adjourned to 24th February.
My lord, peremptorily, my lord, because, my lord, we have
If the
concluded.
appeal is pending, I cannot say peremptorily.
I'm grateful.
My lord, a long date, my lord. If my lord kindly gives it first week of
With
February.
liberty to mention, if the appeal
If
is
it is
disposed of in the
we will-
meantime,
Certain. I'm grateful.
Keep you.
Witness action, item number 11.
My witness has come on your kindly remember last occasion it was allowed my prayer to by recalling the order, the witness actually it was already concluded, but such a
who is the other side?
no, this is undefended suit.
একটা উইটনেস একবার হয়ে গেছিল।
এই মামলাতে আগে সাক্ষ্য দিয়েছেন?
হ্যাঁ। আমার নাম হচ্ছে মিরাজ রশিদ।
আরেকবার ওটা অ্যাডমিনিস্ট্রেট করো। ডিসচার্জ হয়েছিলেন ওর থেকে।
আমি বলছি আমার সাথে বলবেন, ঠিক আছে? আমি শপথপূর্বক বলছি
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো,
যা বলবো সত্য বলবো,
সত্য বই মিথ্যে বলবো না,
সত্য বই মিথ্যে বলবো না,
কোনো কথা গোপন করবো না।
কোনো কথা গোপন করবো না। আমার নাম মিরাজ রশিদ।
মিরাজ রশিদ। স্পেলিং একটু বলবেন?
MERAJRASHID। হারুন রশিদ, লেট। HARUNRASHID।
বয়স?
আমার বয়স হচ্ছে 52।
করেন আপনি?
আমি বিজনেসম্যান আছি। 8 AK মোহাম্মদ MD, সিদ্দিকি লেন SIDDIQUE লেন, কলকাতা 7,16,000।
Yes, sir.
করে দিয়েছি।
Mr. Rashid, last occasion, in answer to question number 9, you deposed that I am the landlord of the suit property. You have also said in answer to question number 11 that you became the absolute owner of the suit property in 1998. Kindly explain how you became the absolute owner of the suit property.
নাম্বার 9 এ আপনি বলেছিলেন আপনি সুট প্রপার্টি ল্যান্ডলর্ড। আপনি
প্রশ্নটা এইভাবে নাও না, হাউ ইউ বিকাম অ্যাবসলিউট ওনার অ্যাজ ইউ ডিপোজড।
যে বলেছেন যে আপনি
কোশ্চেনটা দেখো, হাউ ইউ বিকেম অ্যাবসলিউট ওনার অফ দি সুট প্রপার্টি অ্যাজ কমা দিয়ে অ্যাজ ইউ ডিপোজড।
বুঝতে পেরেছি।
কিভাবে মালিক হয়েছেন এই সম্পত্তিটার বলুন?
আমরা প্রথমে বাবা, মা আর আমি তিনজনে মিলে প্রপার্টিটা নিই মাই লর্ড।
নি মানে
আমরা প্রপার্টিটা কিনি,
পারচেজ করেন,
পারচেস করি,
রেজিস্টার ডিড অফ কনভেন্স করে।
রেজিস্টার ডিড অর
তাহলে এইভাবে লেখো, মি মাই ফাদার, me along with my parents purchased the suit property by a registered instrument.
তার মধ্যে বাবা ছিলেন 50% ওনার, আর আমি আর মা ছিলাম 50% ওনার।
Full stop. After full stop, 50% of the property owned by my father. Full stop. My mother and me were co-owners in respect of the rest 50% of the property. Is it okay?
Yes, my
Malad,
lord.
Malad. Absolutely. I'm
Show the
showing,
deed.
Malad, two deeds. Malad, I'm showing you two documents.
Identify these documents. These documents.
এই 12 মার্চ 1982 এটা হচ্ছে যে 50% আমার বাবা যেটা ওনার ছিলেন, মানে ল্যান্ডলর্ড পারচেসিং করেছিল।
This is the registered instrument by which my father purchased, my father became 50% owner of the suit property. Is it suit property?
Malad.
Suit property. মার্ক করে দাও, কি হবে দেখো এটা, তুমি এটা করে দাও, this instrument bears date of 12/3, মার্ক করো।
মাই লর্ড, দ্বিতীয় ডকুমেন্টটা হচ্ছে সেকেন্ড ডকুমেন্ট, এটা হচ্ছে আমার মা আর আমরা দুজনে মিলে যে রেস্ট অফ দ্য প্রপার্টিটা কিনেছিলাম।
This is the registered instrument by which I and my mother became 50% owner of the suit property. We purchased the suit property under this registered instrument.
Malad, I'm grateful. Kindly tell my lord, thereafter how became the absolute owner of the suit property?
তারপরে 1998-এ বাবা মা আমাকে গিফট দলিল করে ল্যান্ডলর্ড বানিয়ে দেয়, আর বাবা মা আমাকে গিফট করে দেন রেস্ট অফ দ্য প্রপার্টি।
My father and mother jointly made a registered deed of gift by which I became and gave me and gifted me the rest of the property.
And transferred their respective shares of the property unto me.
I become the absolute owner of the property. I became the absolute owner of the suit property.
I'm showing you two documents. Kindly tell my lord, what is this document about?
এই ডকুমেন্টগুলো কি ব্যাপারে মাই লর্ড কে বলুন।
মাই লর্ড, এটা হচ্ছে, এই ডকুমেন্টসটা হচ্ছে যেটা আমার বাবা আমাকে গিফট করেছিলেন।
This is the instrument, registered instrument by which my father transferred by way of gift his proportionate share and ownership of the suit property, marked as Exhibit E.
এই যে দলিলটা আছে, এটা মা আমাকে বাকিটা গিফট করে দিয়েছিলেন।
This is the registered instrument by which my mother transferred her respective ownership and share of the suit property to me.
In answer to question number 11, you also depose that Mrs. C.D. Phillips was the tenant in respect of the suit property in a particular flat. Is it so?
This is leading question.
Madam, I'm sorry. You also deposed that Mrs. C.D. Phillips was the tenant of C.D. Phillips was the tenant of the suit property. He deposed.
Mr. C.D. Philip.
No, Mrs. C.D. Philip.
How Mrs. C.D. Philip was related to the suit property?
My lord, আমরা যখন প্রপার্টিটা নেই তখন মিসেস সিডি ফিলিপস টেনেন্ট ছিলেন।
এটা টু দি কোর্ট করে নেবে না কিন্তু, যেটা টু দি কোর্ট করতে হবে আমি বলে দেবো, এটা এমনি নাও।
At that point of time, when we purchased the property, when we purchased the suit property, C.D. Philip was a tenant.
Flat number 4.
Of flat number 4.
How long Mrs. C.D. Philip was tenant under you?
আপনাদের আপনাদের অধীনে কতদিন টেনেন্ট ছিলেন?
মাই লর্ড, উনি ডেটটা তো আমার ঠিক মনে নেই, কিন্তু আমি যখন 1998-এ
কত বছর ছিলেন বলতে পারবেন?
Up to which year she stayed over there as a tenant?
কত সাল পর্যন্ত উনি ছিলেন ওখানে?
সেটা মাই লর্ড যে প্রথমে যখন উইটনেস দিয়েছিলাম সেখানে বলে দিয়েছিলাম, আমার ঠিক এখন মনে নেই মাই লর্ড।
I cannot exactly remember how long Mrs. C.D. Philip was stayed in the suit property as a tenant. I have already full stop there. I have already deposed that.
প্রথম উইটনেস আমি বলে দিয়েছিলাম।
Can you tell my lord when Mrs. C.D. Philip paid the last paid the rent? Up to which period Mrs. C.D. Philip paid the rent?
সময় পর্যন্ত ভাড়া দিয়েছিলেন বলতে পারবেন?
আমি প্রথম উইটনেস যখন দিয়েছিলাম সেই সময় আমি সব বলে দিয়েছিলাম।
I cannot remember right now. How long Mrs. C.D. Philip paid rent? I have already deposed on that. I have already deposed on this point. Why are you making repeated question?
My lord,
He is not feeling free. We cannot remember.
My lord, প্রথমে বলে দিয়েছিলাম।
Yes, then why are you repeating?
I'm sorry, my lord. In answer to question number 48, you produced 2 documents which was marked as X for identification. That is the photocopy of the document. As you could not the original at that point of time.
What is your question?
Now, have you taken step to get the certified copy of the same?
Again, leading question. You are asking leading question. What is that document?
A document, well, 2 documents. One is Metropolitan Magistrate passed an order and one application under 44(2) CRPC. Well, 2 documents were produced. It was marked as X for identification.
Show
Since
documents, X documents marked as X for identification to the witness. What a legal shown the documents marked as X for identification to the witness.
আমি সার্টিফাইড কপি তোলার জন্য আমি স্টেপ নিয়েছিলাম, কিন্তু সেখানেও আপনার মেট্রোপলিটনের এর মধ্যে ওখানেও খুঁজে পেলাম না ওটা। তার রিসিট আছে আমার কাছে। রিসিভ কপি যে আমি এটা ফাইল করেছিলাম তার রিসিভ কপিটা রয়েছে।
Of my application for obtaining certified copy.
I'm showing you one document. Kindly tell my lord, what is this document about?
এই ডকুমেন্টটা কি মানে?
My lord, এটাই হচ্ছে ওই যে রিসিটটা যেটা আমি
This is the original counterpart of the application made by me for obtaining certified copies of Exhibit X or of documents marked as X.
Well, that's all.
That question is not put. Where are you so eager?
My lord,
document may be marked as Exhibit G, possibly.
G, my lord. Well, that's all, my lord. I don't know.
Thank you, my lord.
PW1 is re-examined, recalled and re-examined and discharged. Fix. Date bolo. এই মাসে মাঝে মাঝে বলবে ডিসপ্লে করতে 13, 14, 15 কি আছে? তুমি কবে বলছো? 22nd January for argument.
I'm good.
Item number 12.
The appeal for the defendant. My witness was in the box for being cross-examined by Mr. Moinak.
When Mr. Bose is coming.
You start cross-examining.
Yes, yes. Already the minister of the cross. Good, I done. Finished.
मेरा नाम ओम प्रकाश रुइया। RUIA.
Further cross-examination, I think.
2 days he was there.
Further cross-examination resumed.
The exhibit C will be shown to the witness. Exhibit C. Exhibit. This is also plain. This document also appears at pages 69 and 70 of the plaintiff's brief.
So as exhibit C.
Yes.
C. That's it. C. The question for it is which exhibit C. 69.
Mr. Ruia, kindly have a look at this document and tell my lord as to whether if I will be correct in saying that the trust cancel the deed and return the check for rupees 2 lakhs.
डॉक्यूमेंट को देखिए और माइलॉट को बोलिए क्या वो सही बोल रहे हैं कि ट्रस्ट ने डीड को कैंसिल किया था और 2 लाख रुपए का चेक
अभी ये चेक हमने रिटर्न किया।
Mr. Ruya, would it be correct in saying that prior to the agreement between the parties dated 28th of January 2005, there was a previous deal for sale of the subject property of the trust?
सही होगा कि एग्रीमेंट 28 जनवरी 2005 की एग्रीमेंट से पहले एक और डीड था प्रॉपर्टी को बेचने के लिए पहले से एक एग्रीमेंट था, क्या ये बोलना सही होगा?
इनके साथ में तो 28 जनवरी को हुआ था डील 28 जनवरी और
मतलब किन के साथ हुआ था वो
ये माइती जी के साथ।
नहीं, एक बार क्वेश्चनটা পড়ে দিন।
Correct in saying that prior to the agreement between the parties dated 28 January 5, there was a previous breach for sale of the state property of the tree
Between the parties.
between the parties.
28 जनवरी
Deal, DEAL, deed ना,
Deal
deal,
for sale. Deal
DEAL.
for sale.
28 जनवरी 2005 के जो एग्रीमेंट था उससे पहले भी जो प्रॉपर्टी था उस प्रॉपर्टी को बेचने के लिए और इससे पहले भी एक और डीड था। क्या ये सही
अरे
है?
deed नॉट
डील
डील हुआ था, क्या ये सही है?
इनके साथ में 28 जनवरी 2005 को ही हुआ था डील।
On 28 January 2005, a deal was made with the party, between the parties.
Is it your evidence that there was no deal between the parties prior to wait, date বলো তো? 28? Yes. Is it your evidence that prior to January 2005 there was no prior deal, or that you are unaware whether there was such deal or not?
28 जनवरी 2005 के पहले कोई डील नहीं था पार्टीज के बीच में और हो सकता है उससे आपको पता नहीं है। क्या ये सही है?
ना
क्या ये कहना सही होगा?
28 जनवरी को ही इनके साथ में एक महीने का 28 फरवरी तक का भीतर में पूरा रुपया देने का बात था।
28 January, a deal was made with them in which it was mentioned that in a month, that is 28 February 2005, they will repay the whole amount. They will pay the entire amount.
बट इन्होंने पेमेंट देने में यह सुविधा जताई कि पेमेंट नहीं हो रहा तो इनको फिर 15 दिन का मोहलत दिया गया।
Let us know their difficulty, pay the amount within this period of time and ask for 15 days time more.
बट उन्होंने टाइम देने के बावजूद भी पैसा का व्यवस्था नहीं कर सके। इनको बोल दिया गया था
The time was given to 15 days time was given to them. They could not arrange the money and
यदि आप 15 मार्च के भीतर यदि ये पेमेंट नहीं करते तो जो रुपया आपका दिया हुआ है वो फोरफिट हो जाएगा।
ultimatum was given to them that if they could not pay the money within 15 March 2005, the money they have already paid shall be forfeited.
इन्होंने इस अवधि में केवल 5 लाख रुपया और दिया। जो हमारा डील था 35 लाख का, आउट ऑफ 35 लाख 15 लाख रुपया तो दे दिया था।
Out of 35 lakhs, you have paid an amount of rupees 15 lakhs only.
15 लाख विदिन 28 फरवरी
Within 28 February 2005.
5 thereafter 5 lakh
And after
in the month of March.
they paid amount of rupees 5 lakh in the month of March 2005.
2005.
Are you aware? No, it is. Mr. Ruya, are you or are you not aware of any prior deal, any deal between the parties prior to January 2005 for sale of the subject property between the parties? Please answer in yes or no.
जनवरी 2005 के पहले प्रॉपर्टी था उसको बेचने के बारे में कोई डील हुआ पार्टीज के बारे में, इस बारे में आपको पता है या नहीं?
हाँ या ना?
इस पार्टी से तो 28 फरवरी
Say yes or no.
फिर से बोलिए एक बार।
जनवरी 2005 से पहले जो प्रॉपर्टी था उसके बेचने के सिलसिले में पार्टियों के बीच में कोई डील हुआ था, इस बारे में आपको पता है या नहीं?
ना, इसके पहले नहीं हुआ। नो,
पता है डील हुआ था हाँ या ना?
डील हुआ था हाँ या नहीं?
ना।
Well, it's shown plaintiff document number 30 PD 13 ওইটা দেখা shown PD 13 exhibit C a letter dated 26th April 2003 issued by the defendant trust. I put it to you that there was a prior deal between the parties for sale of the subject property, and in terms thereof, rupees 2 lakh was paid by the plaintiffs, which was subsequently returned by the trust. And the deal and the said deal was cancelled and the amount was returned by the trust by this letter dated 26th of April 2003.
वो आपको सजेशन दे रहे हैं, आप मान भी सकते हैं या नहीं भी मान सकते हैं। वो कह रहे हैं कि ये जो लेटर है 26 अप्रैल 2003 का, लेटर के जरिए ये पता चल रहा है कि ट्रायल डील हुआ था सूट प्रॉपर्टी जो था उसको बेचने के लिए, जिसके चलते प्लेंटिफ ने 2 लाख रुपया दिया था और ये 2 लाख रुपया ट्रस्ट ने रिटर्न किया था डील को कैंसिल करके। हाँ या ना में जवाब दीजिए पहले, क्या आप मानते हैं या नहीं मानते हैं? इस लेटर के जरिए डील को कैंसिल किया गया था।
भाई 2003 की बात है। उस वक्त वो हमारा टर्म्स एंड कंडीशन उनके साथ में फिट नहीं हुआ था, इसलिए हमने कैंसिल कर दिया।
आप क्वेश्चन जो पूछ रहे हैं ना उसको समझिए, फिर जवाब दे दीजिए। अगर जरूरत पड़ेगा तो दोबारा पूछ लीजिए।
हाँ सर, वही मैंने पूछा दोबारा। आप हाँ बोलो।
ये जो 26 अप्रैल 2003 का जो चिट्ठी है, इस चिट्ठी के जरिए एक प्रायर डील हुआ था पार्टियों के बीच में सूट प्रॉपर्टी को बेचने के लिए, जिसके चलते प्लेंटिफ ने 2 लाख रुपया दिया था ट्रस्ट को और ट्रस्ट ने इस चिट्ठी के जरिए वो डील को कैंसिल किया और वो 2 लाख रुपया रिटर्न किया। आप मानते हैं या नहीं मानते हैं? चिट्ठी को देखिए और बोलिए।
Mr. Bush, read your question. What this letter is about?
चिट्ठी किस बारे में है बताइए।
ये तो चेक रिटर्न किया सर, उस बारे में है।
This is a letter related to return of a check.
That is why, my lord, my question is in the form of a suggestion.
Now you ask this one.
এই পেশেন্টে বা জিজ্ঞেস করুন।
From Exhibit C, it dated 26 April 2003, issued by the defendant trust. I believe that there was a prior deal between the parties of sale of the subject property, and in terms thereof, rupees 2 lakhs was paid by the plaintiff, which was subsequently returned by the trust, and the said deed was cancelled and the amount was returned by the trust. By this letter dated 26 April 2003.
एक प्रायर डील हुआ था पार्टियों के बीच में ये सूट प्रॉपर्टी को बेचने के लिए प्लेंटिफ ने 2 लाख रुपया
He's just buying time to think of an answer. Now he's aware, he can understand the question very well because he doesn't have an answer. He's thinking about an answer.
जवाब दीजिए ये सब नो बोलते
जवाब दीजिए।
हाँ सर,
पहले एक डील
हुआ था फिर वो कैंसिल कर दिया।
So yes, that is correct.
वो सही बोल रहे हैं या गलत बोल रहे हैं? आप
नहीं,
राजी है?
नहीं, ये चिट्ठी के हिसाब से सही है, अकॉर्डिंग टू लेटर।
अकॉर्डिंग टू
Mr. Ruya, are you aware of the consequences of giving false evidence before this honorable court?
क्या आपको पता है?
এটা ওটাকে ভালো করে বোঝা।
क्या आपको पता है झूठी गवाही देने का मतलब क्या है? क्या सजा हो सकता है आपको कोर्ट के सामने?
मैंने कोई झूठी गवाही नहीं दी है।
नहीं, आपको पता है हाँ या ना में जवाब दीजिए।
ना,
आपको
मेरे को नहीं पता।
में पता है क्या हो
नहीं,
हो सकता है?
मेरे को नहीं पता।
हाँ, वो बोलिए।
I don't know. I am not aware of the consequences of giving false evidence.
Well, he should be made aware of the consequences of giving false evidence.
বুঝিয়ে দিন বুঝিয়ে দাও
বুঝিয়ে দিন যে আমি তো বলতে পারি না কোশ্চেনে।
আপনার জেল পর্যন্ত হতে পারে ভুল आपको जेल तक हो सकता है।
भाई मेरे को जितनी जानकारी है,
नहीं जानकारी के बारे में अगर आप
मेरे को जो
अगर प्रूव होता है कि आप गलत फॉल्स एविडेंस दे रहे हैं तो ये
आपको जितने याद आते हैं
उतना
जल्दी जल्दी जवाब दीजिए, सोच के बूझ के ऐसा नहीं।
सर ये मैटर 22 साल पहले 20 साल पहले का है, तो इतना तो सर कल क्या खाया हमको वही याद नहीं।
He remembers everything of 2005, but he doesn't remember anything of 2003. This selective memory is very dangerous.
You know how it happens.
Yes.
We'll face it in sessions trial.
Next. Well, shown question and answer to in cross-examination question 32. 32 er cross-examination question and answer take to that. আমারটা মার্ক করা 32 No. Question 32. একটু ওকে কোশ্চেনটা পড়ে দিন, আনসারটা কি দিয়েছে একটু বলে দিন।
यहाँ पर लिखा हुआ है what happened after Mr. Beheti paid to pay the money after 15th March 2005. Mr. Beheti जब 15 मार्च 2005 तक वो जो मनी उनको देना था पैसे वो नहीं दे पाए, उसके बाद क्या हुआ? आपने जवाब दिया था he has been informed that if you were unable to pay the money within 15 days then your money will be forfeited. आपने कहा था इनको ये बताया गया था कि अगर 15 दिन के अंदर अंदर आप पैसे नहीं दे पाए तो आपने जो मनी दिया था वो फोरफिटेड।
एकदम सही बात है।
Who had informed this and to whom?
जो आपने बोला ना इन्फॉर्म किया गया था, इन्फॉर्म किसने किया था और किसको किया गया था?
ये तो बाइती जी और हरिराम जी जालूका या हमारे प्रेसिडेंट साहब तोलाराम जी जालान, इन्हों का
प्रश्न को समझिए। ये इंफॉर्मेशन किसने दिया था और
किसको दिया
था? किसने दिया था पहले बताइए।
किसने दिया था कि कैंसिल के लिए?
तो आपने लिखा है ना ही हैज बीन इन्फॉर्म्ड,
हाँ,
ना इंफॉर्मेशन किसने दिया था?
और मिस्टर आचार्य जालूका ने।
अच्छा,
हरिराम जालूका।
हरिराम जालूका। और किसको दिया था?
इंफॉर्मेशन वाज गिवन बाय मिस्टर
बाइती जी को, श्री गोपाल जी बाइती,
and was given to Mr. Sri Gopal Beheti. Stop. Shown plaintiff's document number 5. Page 21.
Yes, sir.
Yes, sir. I put it to you that the defendant trust, by their resolution dated 18th of October 2004, had entrusted Mr. Tia Jalan, one of the trustees of the trust, entrusted টা authorized করে দিন, to negotiate with intending buyers and take all steps necessary for sale of the subject property.
I put to you that the defendant trust by their resolution dated 18th.
Only Mr. Suggestion, only Mr. Tia Jalan. Only only Mr. Tia Jalan.
दे रहे हैं कि डिफेंडेंट ट्रस्ट की 18 अक्टूबर 2004 की रेजोल्यूशन के तहत मिस्टर टीआर जालान को ये ऑथराइज किया गया था कि वो इस प्रॉपर्टी की सेल के बारे में नेगोशिएट करे पार्टीज से। क्या आप ये मानते हैं या नहीं मानते?
हाँ जी, मानता हूं मैं।
I put it to you that Mr. Hariram Jaluka was neither authorized nor was competent to negotiate or hold any discussion on behalf of the trust with any party, including the plaintiff.
आपको सजेशन दे रहे हैं, आप मान सकते हैं नहीं मान सकते। वो कह रहे हैं कि मिस्टर एचआर जलूका को कोई भी ऑथराइजेशन नहीं दिया गया था और वो इस काम के काबिल भी नहीं थे कि वो पार्टीज के साथ कोई नेगोशिएट करे इस प्रॉपर्टी को बेचने के बारे में।
हरिराम जी जालका को पूरा अधिकार दिया गया था।
Say I agree or I disagree. हम मानते हैं या
हाँ,
नहीं?
मानता हूं मैं, उनको अधिकार दिया गया था।
नहीं दिया गया था एचआर जलूका जी को।
अच्छा, जालका जी से को दिया गया था।
So then you say I disagree. बोले जेटा बोलचे उठा ली दिए जेटा बोल दिया गया था।
हरिराम जी जालका को अधिकार दिया गया था।
Mr. Teacher Jaluka was also given the right.
Kindly show from the records of this honorable tribunal any document that would, from which it would be evident that Mr. Hariram Jaluka was authorized by the trust to negotiate or take any steps on behalf of the trust for sale of the subject property.
रिकॉर्ड आपने सबमिट किया है, उन रिकॉर्ड में से क्या आप दिखा सकते, कोई रिकॉर्ड दिखा सकते हैं जिससे ये साबित हो सके कि मिस्टर एचआर जालूका को ये ऑथराइज किया गया था और
Authorized by the trust.
ट्रस्ट की तरफ से ऑथराइज किया गया था कि वो डील को नेगोशिएट करे इस
या कोई स्टेप्स ले,
या कोई स्टेप ले प्रॉपर्टी को बेचने के मामले में। आप कोई डॉक्यूमेंट दिखा सकते हैं रिकॉर्ड में से?
फिर वो तो हमारे लाइयर साहब बोल सकते हैं।
आप एक आंसर दिए हैं, आंसर के बेसिस पे आपको डॉक्यूमेंट दिखाने पड़े। आपका लॉयर साहब आपको हेल्प नहीं कर सकता।
मिस्टर एचआर जालूका जी को राइट दिया गया था। अब वो कह रहे हैं कि आप कोई रिकॉर्ड दिखा सकते हैं कि राइट दिया गया था, उनको ऑथराइज किया गया था ट्रस्ट की तरफ से।
इतना तो सर ये पुराना बात मेरे को याद नहीं है।
I cannot remember.
I can't remember that.
I put it to you that you have been deliberately making, you have been deliberately giving false evidence and there has never been any discussions between Mr. H.R. Jaluka and Mr. Gopal Baheti in respect of sale or purchase of the subject property. In respect of the subject property. In respect of the subject property.
वो कह रहे हैं कि आप जानबूझकर गलत गवाही दे रहे हैं और मिस्टर टीचर चालुका और गोपाल बहेती के बीच में प्रॉपर्टी की बेचने के मामले में कोई भी बातचीत नहीं हुआ था। क्या आप इस बात को मानते हैं या नहीं?
नहीं, मैं नहीं मानता।
I put it to you, I disagree. I put it to you that neither Mr. H.R. Jaluka nor any other person ever informed Mr. Gopal Baheti or any other representative, authorized representative of the plaintiff regarding forfeiture of the part consideration paid by the plaintiff if they were unable to pay the balance within 15 days, as has been alleged by you in answer to question 32.
वो आपको सजेशन दे रहे हैं, मान भी सकते हैं, नहीं भी मान सकते हैं। वो कह रहे हैं कि मिस्टर टीचर चालुका और किसी दूसरे आदमी ने मिस्टर गोपाल बहेती और प्लेंटिव कंपनी की किसी भी रिप्रेजेंटेटिव को ये नहीं बताया था कि जो मनी उन्होंने दिया था वो फोर्फिटेड हो जाएगा अगर वो बैलेंस अमाउंट 15 दिन में नहीं दे पाते हैं। तो आप ये बात मानते हैं या नहीं मानते हैं?
नहीं, ये बात तो सही है कि 15 दिन का उनको मोहलत दिया गया था।
वो कह रहे हैं मिस्टर एच.आर. जलूका और किसी और पर्सन ने मिस्टर गोपाल बहेती या कंपनी की किसी भी रिप्रेजेंटेटिव को ये नहीं बताया था कि जो मनी उन्होंने दिया था ये प्रॉपर्टी खरीदने के लिए वो फोर्फिटेड हो जाएगा अगर 15 दिन के अंदर अंदर वो बैलेंस अमाउंट नहीं दे पाए। तो आप क्या ये मानते हैं या नहीं मानते हैं?
ये बात तो सत्य है कि ये हम लोगों ने कहा था 15 दिन के भीतर यदि आप नहीं देंगे।
समझा क्वेश्चन को? नहीं समझा?
नहीं समझा। Oh,
Giving the right answer.
yeah, of course, indeed.
No,
Question
he's
is
saying-
something else.
No.
Whatever is the question, his answer is the same.
That Mr. Bose cannot say, man. What he's saying, let it go down.
समझा? आप
Yes, to answer the question and then say whatever. he
आप
has.
समझा क्वेश्चन?
हाँ सर, क्वेश्चन तो समझा, ये यही
ठीक है, तो आंसर क्या है?
ये बात उनको बोला गया था यदि इस तारीख के भीतर नहीं देंगे।
एग्री करते हैं नहीं करते हैं?
मैं एग्री करता हूँ ये बात।
The rest of the answer should go, man. The rest of the answer, what he's saying. So the other
Because it is
Then say it.
irrelevant.
Then say it.
Then say, nah.
मैं ये बोलना चाहता हूँ कि 28 फरवरी का डेडलाइन था। 28 फरवरी
28 February 2005
Deadline of what?
फॉर पेमेंट।
The deadline for payment was 28 February 2005.
बाईती जी आकर रिक्वेस्ट किए कि पैसा का व्यवस्था नहीं हो रहा है।
Mr. Baheti, he could not arrange the money.
विद इन 28 फरवरी उन्होंने 15 लाख रुपया दिया।
Within 28 February 2005, they paid amount of rupees 50 lakh.
देयर आफ्टर मार्च 5 या 3 उन्होंने 5 लाख रुपया और दिया।
Thereafter, on March 5th March or 3rd or 5th March
Of 2005.
of
2005
he gives an amount of rupees 5 lakhs.
Inconsistent with prevail if it is so.
उनको बोल दिया गया था ये 15 तारीख को आपको हम डेट एक्सटेंशन कर रहे हैं, हमको इसमें यदि रुपया नहीं दिया गया तो ये रुपया आपका फॉरफिटेड है 20 लाख।
Mr. Bosch, whatever answer he will give, it will
Correct,
go.
correct, absolute.
If there is inconsistency,
Absolute.
then you know what is the advantage for you.
Absolutely. Absolutely. I will just, that's why I'm giving suggestion. Now he is answering, giving answers to suggestions also.
Let him.
Can be forfeited.
Mr. Ruya, I put it to you that there are no documents on record to suggest that a period of 15 days from 28 February 2005 was extended by the defendant trust. And your evidence to that extent is false.
वो कह रहे हैं कि 28 फरवरी 2005 से 15 दिन का जो एक्स्ट्रा मोहलत दिया गया था, इसका कोई भी डॉक्यूमेंट नहीं है। क्या आप इस बात को मानते हैं या नहीं मानते?
And Judge,
वो कह रहे हैं कि इसके चलते आपका जो एविडेंस है वो फॉल्स है।
भाई बात तो मेरे सामने में हुई
आप
थी।
एग्री करते हैं नहीं करते हैं?
कोई डॉक्यूमेंट है हाँ या ना?
दिया गया था उसका कोई
सर
डॉक्यूमेंट है या नहीं है? 15 डेज एक्सटेंशन का कोई डॉक्यूमेंट है या नहीं है?
सर होना चाहिए, डॉक्यूमेंट होना चाहिए।
तो देखिए और
इशू
निकालिए।
इज नॉट होना चाहिए, इशू इज वेदर इट इज देयर और नॉट, वेदर डू यू नो और नॉट।
At this time I have no mind.
I cannot remember whether there is any document extending the time period by 15 days.
आंसर तो की बोल लो।
I cannot remember whether there was any document in document
I put
extending
it
the
to-
time period by 15 days.
Correct. I put it to you that there are no such document and that there has never been any extension.
Just a minute. He also made a suggestion to you that you are giving false evidence.
सर ये कैसे, हाउ इट इज पॉसिबल? ये
आप मानते हैं या नहीं मानते हैं?
नहीं, मैं नहीं मानता।
पॉसिबल तो हो ही सकता, कोई आके झूठा गवाही दे सकता है, ये पॉसिबिलिटी का क्या बात है?
नहीं सर, मैं तो जो सामने हुआ वो बोल रहा हूँ सर।
बस ठीक है, वही बोली, आई
हाँ,
डिसएग्री।
बस
आप जो बोल रहा है या जो डॉक्यूमेंट है वो की बोल एट वेरिएंस है। सर हिंदीটা बोलो।
सर मेरे सामने में जो बात हुआ मैं वही बोल रहा हूँ।
हाँ अच्छा, हाँ बात तो सब आप ही के सामने हुआ है।
हाँ जी।
हाँ जी। नेक्स्ट क्वेश्चन। I put it to you that the allegation of extension of time and failure to make payment within the extended period is contrary to clause 4.2 of the agreement dated 28th of January 2005.
वो कह रहे हैं कि जो आप बोल रहे हैं कि टाइम का एक्सटेंशन दिया गया था और टाइम पीरियड में वो लोग पेमेंट नहीं कर पाए, ये क्लॉज 2.4 है,
4.2
4.2
of the agreement
ऑफ एग्रीमेंट का जो 28 जनवरी
is contrary to clause 4.2 of the agreement. आप ये मानते हैं हाँ या ना?
5 को किया गया था, उसकी क्लॉज के 4.2 से नहीं जाता है, कॉन्ट्रारी है, विपरीत है। आप ये मानते हैं या नहीं मानते?
जब तक नहीं देखूं तो मैं क्या
अच्छा
बोलूं?
देखिए
डॉक्यूमेंट
ना बोला तो
Witness is shown the document to refresh memory.
4.2 টেক টু দেখা সেকেন্ড পেজে উপরের দিকে 4.2
हाँ, क्या बोलना है? Balance payment is to be paid by the purchasers to the vendor at the time of execution and registration of the conveyance within a- एकदम ठीक बात है। 28 फरवरी के भीतर में देने का बात था।
कह रहे हैं आपसे, ये जो एक्सटेंशन ऑफ टाइम का बात आप कर रहे हैं और जो बोल रहे हैं जब पेमेंट का फेलियर हुआ था, वो लोग पेमेंट नहीं कर पाए उन 15 दिनों में,
ये 28
वो उस बात से इस क्लॉज पूरा विपरीत है, वो कह रहे हैं। आप इस
ये
बात को
28
आप
फरवरी
मानते हैं हाँ या ना, फिर जो बोलना है बोलिए। मानते हैं हम जो बोल रहे हैं कि हाँ या ना में जवाब दीजिए।
हाँ, ये 28 फरवरी, हाँ।
बिना বুঝতে পারলে সাক্ষী দিতে এসছে কেন ভাই?
नहीं नहीं, साक्षी दीते ये लोग जा जा जानी।
No, please explain to him the question. The question is very simple.
आप कह रहे हैं
आप जो बोले हैं हम बोल रहे हैं वो क्लॉज 4.2 के ऑपोजिट है।
ऑपोजिट विपरीत है।
सर, ये एग्रीमेंट पहले का हुआ हुआ है।
मानते हैं नहीं मानते हैं? उनका कहना है आप जो बोलते हैं वो क्लॉज 4.8
4.2
4.2 का अलग नहीं है, उससे उल्टा है। आप मानते हैं नहीं मानते हैं?
मानता हूं सर, ये जो है।
मानता हूं तो लिखूं आई एग्री। नेक्स्ट क्वेश्चन। shown on question and answer 2 in cross examination, shown question 34 in cross examination, question and answer of 34 in cross examination, और আমি বলে দেবো ওটা in answer to question 34, question টা লিখে নিন, in answer to question 34 you have alleged that Mr. Baheti used to say that he was unable to arrange money. He used to say that he was unable to arrange money. To whom did Mr. Baheti, to whom according to you did Mr. Baheti say this to?
क्वेश्चन नंबर 34 ने आपने कहा था कि मिस्टर बेहती ने कहा था कि वो पैसों का बंदोबस्त नहीं कर पाए। किसको कहा था उन्होंने पैसों का बंदोबस्त नहीं कर पाए?
वो मिस्टर HR जालू का।
He said this to Mr. HR.
I put it to you that Mr. Gopal Baheti never had any discussion in respect of the subject property with Mr. HR Jaluka, and the question of making such statement by him could not and did not arise.
कह रहे हैं जो प्रॉपर्टी था उसको बेचने के बारे में मिस्टर गोपाल बहेती के साथ मिस्टर सुल्तान जलूका का कभी भी कोई बातचीत नहीं हुआ था, तो ये क्वेश्चन अराइज ही नहीं करता है कि उन्होंने मिस्टर जलूका को ये बात बताया था।
मेरे सामने में सर बात होती थी, मैं तो जो सुना वही बता रहा हूँ।
Discuss properly and just uttered what I have heard. I have uttered what I have.
I have heard.
I am saying what I have heard. I am saying what I have heard. I put it to you that since such discussions never took place, the question of you hearing the same did not arise, would not have arisen, and you are giving false evidence to that extent.
कह रहे हैं ऐसा कोई
वो कह रहे हैं कि वकील बाबू बोल रहा है,
वो कह रहा है
को सजेशन दे रहे हैं कि ऐसा कोई डिस्कशन हुआ ही नहीं था, तो आपको सुनने का बात पैदा ही नहीं होता है और आप जो कुछ भी बोल रहे हैं वो फॉल्स एविडेंस है। आप झूठी गवाही दे रहे हैं।
मैं झूठ किस लिए दूंगा?
आप ये मानते हैं कि नहीं मानते?
नहीं मानता मैं।
ना। Lordship kindly gives us one moment. I think one or two last questions.
He's PW1, PW2.
No, DW. नहीं। I put it to you that the plaintiff was always ready and willing and still is ready and willing to make payment of the balance consideration, but the defendant refused to execute and register the deed of conveyance, for which the present suit was initiated by the plaintiff.
वकील साहब आपसे कह रहे हैं कि प्लेंटिफ रेडी प्लेंटिफ प्रस्तुत थे और इच्छुक भी थे, जो बैलेंस कंसिडरेशन अमाउंट था, जो पैसे उनको देना था, वो देने के लिए वो इच्छुक भी थे और प्रस्तुत भी थे। और ये डिफेंडेंट है जिन्होंने बैलेंस कंसिडरेशन को नहीं दिया और डीड को रजिस्टर नहीं किया, इसके चलते ये मामला दर्ज हुआ है। आप इस बात को मानते हैं या नहीं?
ना नहीं मानता।
I put it to you that you are in no way connected with the defendant trust, comma, you have been unable to produce any document with regard thereto, and as such you are incompetent to depose on behalf of the defendant trust.
वकील साहब आपसे कह रहे हैं आप डिफेंडेंट ट्रस्ट से किसी भी, आपका डिफेंडेंट ट्रस्ट से कोई भी नाता नहीं है, आप किसी भी तरीके से उनसे कनेक्टेड नहीं है।
Mr. Bush, it is not a question of incompetency. Say rather you have known nothing.
And because he's not, I am also saying that he has not been able to produce any document to show that he is in any way connected with the trust. So he becomes incompetent. But he may know something, but otherwise his competence is under
He knows
challenge.
something, but that may be hearsay.
Yes, that may be possible. But then he has to be competent to depose on behalf of somebody. Somebody must authorize him.
Something he may say out of personal knowledge, but that knowledge may be hearsay.
If it is an entity, even if it is an entity, corporation,
Suppose he is
individual,
not representative.
correct.
He is not authorized.
Right.
Yet he can depose, stating some statement of facts, some facts.
But then he has to be authorized by somebody to depose on. If he is not a party,
right.
That's my
All right,
proposition is that.
Question will go.
You are not connected with the defendant trust, you are able to produce in no way connected with the defendant trust.
As such, you are incompetent.
डिफेंडेंट ट्रस्ट से आपका कोई नाता नहीं है। वकील साहब कह रहे हैं डिफेंडेंट ट्रस्ट से आपका कोई नाता नहीं है, आपने इस सिलसिले में कोई भी डॉक्यूमेंट भी प्रोड्यूस नहीं कर पाए हैं और इसके चलते आप यहाँ पर गवाही देने के लिए उपयुक्त
काबिल नहीं है।
काबिल नहीं है।
ठीक है, मैं ट्रस्ट
आप मानते हैं या नहीं मानते हैं?
हॉस्पिटल जो है ट्रस्ट के
मानते हैं नहीं मानते हैं? आई एग्री और डिसएग्री।
वकील साहब की बात से आप सहमत है
क्या नहीं है?
हम डॉक्यूमेंट में लाया हूँ आज उसको डॉक्यूमेंट
आप
सब।
मानते हैं हाँ या ना में जवाब
आपकी बात से सहमत है या नहीं है, पहले ये बताइए। वो कह रहे हैं कि डिफेंडेंट ट्रस्ट के साथ आपका कोई नाता नहीं है।
तीन बात बोलते हैं, एक ट्रस्ट के साथ आपका कोई नाता नहीं है,
नहीं है।
सेकंड आपको कोई जानकारी नहीं है, थर्ड आपको कोई ऑथोराइजेशन नहीं है।
He has not been able to produce any document.
आपने कोई डॉक्यूमेंट प्रोड्यूस नहीं कर पाया।
सर
डू यू एग्री और नॉट?
मैं लाया हूँ सर डॉक्यूमेंट सब। मैं समझा नहीं
पहले जवाब दीजिए, उनको जो कहना है वो आप मानते हैं नहीं मानते हैं?
नहीं, उनकी बात पहले वाली बात के हिसाब से तो मैं मानता हूँ। आज मैं सर सब डॉक्यूमेंट लेकर आया हूँ अस्पताल का। मैं ट्रस्ट का नहीं हूँ कुछ भी, हॉस्पिटल का। मैं हॉस्पिटल इज अंडर ट्रस्ट।
आप पहले बोलिए आप मानते हैं नहीं मानते हैं, से यस और नो, फिर आपको जवाब लेंगे हम।
मानता हूँ मैं।
Then the answer must go, my lord.
यो क्वेश्चन लिखिছো? आई एग्री।
Then the rest of the answer must go.
Then answer, put the answer.
मैं अस्पताल चूंकि ट्रस्ट के अधीन है, मैं अस्पताल का जॉइंट सेक्रेटरी सिंस 2000।
Then आस्ते आस्ते बोलो, लिखो।
आप सेक्रेटरी हो?
Joint
Joint secretary. I am joint secretary of the hospital.
Joint secretary of the hospital, which is under the trust.
And the trust comes under the hospital. ऐसा है तो
ट्रस्ट नहीं, ट्रस्ट के अंतर्गत हॉस्पिटल है।
अच्छा,
He's not interpreting it. The hospital comes under the trust.
hospital comes under the trust.
বুঝছে না ভাই আমি কি করব?
सही लिखेছে।
Then he has given some more answers, my lord. No, no.
फिर बोलिए।
He has said nothing. No, he has said.
नहीं, he has said something. I have brought all the papers today.
বাবা জজ সাহেব মনে আছে তুই বলো হ্যাঁ he has said that he has brought all the papers. বলবে ও
I have brought all the papers today. That he has said.
पूरा ही मैं लाया हूँ सब।
So that will be all, my lord.
2001 से मैं जॉइंट सेक्रेटरी हूँ। अस्पताल ट्रस्ट के अंतर्गत है और हॉस्पिटल का मैं जनरल जॉइंट सेक्रेटरी हूँ।
কি লাস্ট আনসারটা কি গেল?
হয়তো since 2001
नहीं मैं
Then
लाया
volunteered.
मैं लाया হুঁটা কিভাবে গেল? দরকারি জিনিসটাও বলে।
I am the joint secretary of the hospital which is
Just a minute. Let he, Mr. Mitro, hear it.
since 2001 I am the joint secretary of the hospital which is under the trust. And
I have
brought all the papers today.
Evidence closed. My lord, I want to re-examine the witness.
File application.
I don't think that it's under the Evidence Act 137. It is not a recall. It's only
Re-examination. When
re-examination.
the witness, if the witness is declared hostile or like that.
No, my lord. If not with pleasure, I can file an application, but I'll just put forward.
File an application.
No, that I can do. There's no
You better do that.
because the witness is not discharged. The 137 says the examination of a witness by the party whom is called the examination in chief. Cross-examination, the examination of a witness by the adverse party shall be called the cross-examination. Then re-examination. CPC টা. The examination of a witness subsequent to cross-examination by the party who called him shall be called re-examination. Order 138. Witness shall be first examined in chief, then by the adverse party cross-examined. The examination and cross-examination must relate to the relevance of facts, but cross-examination need not be confined to the witness testimony. Direction for re-examination. Re-examination shall be directed to the explanation of matters referred to in cross. So this is the first leg of re-examination. For explaining matters in cross, and it is disjunctive, and if new matter is by permission of the court introduced, so then I require a permission of the court if I introduce new matter introduced in re-examination, the adverse party may further cross-examination upon that. So it two legs.
In case of re-examination, he can cross-examine.
Yes, if I just clarify. These two things. One is for explaining matters in cross. I respectfully submit, my lord. I
I'm
need.
keeping it for further witness action. Come on this day.
I don't need a permission,
I'm not discharging him right
my
now.
lord. But if I introduce new document, new matters. Sorry, if I introduce new matter, then I need a permission. Then maybe application for leave of the court. But explaining matters in cross, it is a matter of course, if I may say. I want to explain matters in cross, and I'm making it open, my lord. These documents were asked twice earlier. On the very first day?
No. So that is again beyond re-examination. Re-examination, your lordship will see, is confined to explanation of matters.
Definitely, he is explaining. This
is explaining. So your
my witness.
Let me do one thing. I'm not discharging him right now.
Yes.
Let the further witness action of DW2 be deferred. Come on the next day. If you think re-examination is needed on
No,
then he has to. Then if he wants re-examination, then he has to satisfy your lordship on re-examination.
I am satisfying your lordship.
Come with an application.
Come with an application.
Right, that would be better.
I am not saying that he cannot. If he satisfy your lordship that he is.
Court may pass.
May pass.
No,
may
court may pass
You just
if new
point out
matter
these
is
issues.
introduced.
You just
If
point
new
out
matter is introduced.
You just point out these issues. I'm giving you leave right now.
I'll just, if my lord special, I can make an application, but I'm making it clear.
DW
on these documents,
two
because
is
these documents
further
are called for in
cross-examined.
the cross.
Full stop. Liberty is prayed for. Leave is prayed for by Mr. Mitro, the learned counsel for the plaintiff, to re-examine.
let the matter appear, let the suit appear in the list for witness action on. একটা ছোট করে date দাও।
দাঁড়াও না। শুরু হবে।
15 January is okay?
15 January, my lord.
15 January.
15 January.
15 is okay?
15 January.
Yes,
10F,
yes,
10F
15
টা
January is fine.
2 PM আছে না অন্য দিন দাও। না না 10F টা অনিরুদ্ধ রায়। আগে পড়ে দাও।
দেখো তাহলে অন্য কি হয়?
17
20?
16 17 any day.
17th we are not there, my lord.
20
To 20th.
20th
20th.
20th
20 January.
20th 20th এই 20 তারিখ